Good evening. This is John Milburn for Laws 12067 Environmental Law. This is week 3 in term 2. Sorry, week 3 in 2017. We are dealing tonight with the common law. Before we do that, we're going to finish some matters that were for week 2, and then we'll look ahead. I'll start by giving some overview of what I have in mind for the next few weeks. So to do that, I'll share the screen. You should shortly be seeing a Word document, and that Word document contains an overview of what I plan to do in the next 4 or 5 weeks. So next week, we're dealing with international environmental law and federal governance. A lot of reading for you to do in advance. So that's chapters 4, 5, and 6 from your text. In addition to that, just as a reminder, I do expect people to do the weekly online tutorial activities and upload their response. It's a good idea to do that, particularly this year with an at-home examination, and there's a fair chance that some of the questions in the exam may closely relate to the weekly tutorial activities. So please provide your response, upload the response, and that may help you. Don't be afraid to share your information, because if someone likes your answer, they will have to cite you as a source if they choose to adopt some or part of your or some of your response in any question or assignment that may follow. Then we have vacation week commencing on Monday the 4th of December, so there'll be no live lecture then. There'll also be no live session on Tuesday the 12th of December. What I propose to do is provide a recorded lecture or series of lectures in relation to research skills. This will serve as a timely reminder of what we need to do when undertaking research. For those of you that have studied a few subjects in law previously, this may cover some old ground, but we have had some changes. As you're probably aware, Australia has changed recently, and legislation Queensland has changed recently. And common law, of course, is now well and truly gone, replaced by the Federal Register of Legislation. So in terms of key online platforms, there have been some changes, and I'll record that session, which I'm going to use for a number of subjects, including this subject. We already have the online sessions for environmental legislation and ecologically sustainable development. I'm sure that you've seen that on Moodle, and I'll give you a reminder of that. So no live session on week 5. Week 6, we're back to normal while we deal with strategic environmental planning. Then we have vacation week, and I've decided we won't have a live session either for the January New Year holiday, which will be the 2nd of January, but I will provide further recorded lectures. Just as a reminder, we have the 3 assessments for this term. We have the written assessment, number 1, due on the 11th of January, the second on the 25th of January, both of those due at 11:45 or by 11:45 p.m. on the Thursday evening, and both worth 25%. I know that I've mentioned this before, but please make sure that you submit your work on time. It will be very difficult to successfully apply for an assessment adjournment, given that these assessment tasks were made known to you from day 1. And then, of course, we have the final at-home take-home paper. That paper will be available to you online at 5 o'clock on Friday, the 9th of February. It occurred to me that I should mention this. You do need to ensure that you're at a location that has a stable internet connection at that time. You will need to make some arrangements with work, childcare, family, whatever it might be for that day. The fact that you're able to undertake the exam at your computer works to the advantage in that you can be anywhere. You don't have to be at an invigilated examination centre, but it also provides you with an opportunity to do some online research. Now, if for whatever reason you can't access a computer for the exam, you'll need to make some prior arrangements, and you'll need to print the material that you wish to refer to for examination purposes. but I expect that most students, if not everyone, the intention is that you will have access to a computer, prepare a Word document and upload that as part of the assessment. I don't mark draft assessment pieces. So just remember, and of course, I've got a reminder, thank you, don't forget daylight saving. So the times that I'm giving you are Queensland times. Thank you for that reminder, that's excellent. And make sure that you have that appropriate conversion if that's relevant to you. Just going to share the screen again to remind a couple of other things. The first is that I don't mark draft assignments. If you submit your work in Moodle in draft form, I won't respond to it as such, but if it remains in that form, as at the time of the due assessment, which is the 11:45 p.m, for example, on the 11th and 25th of January respectively, I will mark that assignment, even though it's marked as draft, as the final. The next thing is I just want to give you some forewarning that in week 11, I'm going to concentrate on a sample case. It's a case called Booth and Bosworth, 2001 FCA 1453. It's a very interesting case in that it demonstrates clearly the way in which individuals can take action to deal with environmental issues and to promote environmental causes. The case was effectively conducted in two parts of substance, and I have access to the source material, the material that was actually filed in the federal court in that case, including the outline of submissions from the parties. What I propose to do is upload that information. If I haven't already done so, it will appear in week 11. There's a fair chance that the exam will cover some of the material which is contained within that content of Booth and Bosworth. So if you're looking for a case to follow and to use as a guide for some of the assessment work and some of the work that we do during term, have a look at Booth and Bosworth. Now, are there any questions at this stage? No, I think I should just mention in relation to the work that we have for this term, this week, there was some commentary and some YouTube videos involving the Predajon case. One of the reasons I did that primarily was because the Predajon case was a case that was set as an assessment piece for previous offerings of this course. It's not on this occasion. So it won't be as relevant to you as it would have been for students previously. We have the benefit of hearing from Rod Lister QC, who's very well known in this area and was involved as one of the barristers in the Predajon case. Rod speaks very quickly, he thinks very quickly, and I appreciate that that will be a difficult session for you to absorb, but take what you can from it and apply it to your own circumstances. What I'm trying to do by that and other materials is provide you with one practical application at least every week. So to give you an idea of how that fits in with the theoretical material that you have in Bates' textbook, let's have a look briefly at the Moodle site to see what I've got in mind, and so I can give you some idea of the rationale behind the additional material that I've provided for you. Because there's a lot of material, I'm going to give you, as I have tonight in relation to Booth and Bosworth, some hints as to where you might put your priority. But I'll put it all on the material so that you can get a feel for how this is used in practice. Okay, so looking at the assessment material, you'll see that both the first and second assessment have a very real practical application, talking about an actual case and talking about an actual application for environment, which deals with environmental impact. So they're not theoretical, they are matters that are entirely practical. I've given you a fair hint tonight to consider Booth and Bosworth, so there'll be the practical aspect that may be relevant at least for part of the examination. As we look at the additional resources, you'll see that there is information there about planning laws and regulations, so that's very practical in its nature. And then my environmental law series and the chapter comparisons is meant to be more a commentary of the theory from Bates so that you can work your way through that large textbook a little more easily and more efficiently. Now, in terms of the practical side, each week there's something which is intended to be practical. So in week 1, it was undertakings by lawyers and the practice of environmental law, the planning process, of course, as well as some of the diversions, such as does talking to yourself make you a better lawyer? So that's a pretty light introduction to the practical side. In week 2, no practical information per se, but some resources about parliamentary information. Week 3, with the materials that I've been discussing tonight, Rod Litster QC talking with me and students about the Preter-John case was, as indicated, for a previous assessment, but highly practical in the sense that we're dealing with an interview with the QC who was actually involved in the case. Now, you might find the practical material, which is under the heading of further resources, in week 4 of interest. Environmental activist Roger Curry spoke with me and others about the Paradise Dam case, and it's an interesting critique, similar in some ways to the Booth and Bosworth material in that it demonstrates clearly how environmental activists and individuals can make a difference in terms of implementing environmental laws. So the intention of that resource is not examinable per se, as most of these resources that I'm telling you about will be, but something that shows the practical application. So of the material which is, if you like, supplementary or practical in nature that I've shown you so far or talked about so far, it's really the Booth and Bosworth, which I think would be relevant for examination purposes. In week 5, we give you a break. There's no additional supplementary practical material. Week 6, the practical content is really in relation to that commentary about planning and environment law, environmental searches and specialist searches. So if you're undertaking, say, conveyancing, or you are acting for a developer, or you are acting for an environmental objector, you may wish to undertake some specialist searches. So these are this is a way to practically consider strategic environmental planning and assessment in a hands-on manner. So it's a way of undertaking searches about specific properties for looking for issues that may have an environmental flavour about them. The other further resource is from Professor Garrick Small of this university to do with the material about rising sea levels. That is not examinable per se, nor is the commentary about specialist searches examinable per se. I'm not trying to, by making these comments, I'm not trying to dissuade you from looking at the videos or reading the material. Far from it, but I am trying to indicate to you that out of the acknowledged massive material, some will be more relevant than others as far as assessment is concerned. Just returning then to Moodle, if you have any questions as we go, please let me know. The next thing is in week 7, we have environmental impact assessment. This is very important as far as the second assessment piece is concerned. The further resource here is the material by environmental scientist Phil Jeston, who does feature in the video, which is about environmental impact statement with Phil Jeston, and I think there's a series of 2 videos there. The material that is relevant for assessment is more the video material. Don't worry too much about the published material under further resources for assessment purposes. In week 8, I haven't given you any supplementary material there, so it's a bit of a break from other material. Part of the reason for that is you would have noticed the reading for that week is huge. Chapters 12, 13, 14, 15, 16, 17 and 18 for week 8 alone. Now, I probably deserve to give you some comment and hint there. I'm not going to cover a lot of material in terms of examination from the text, given there is so much reading there. So I would like you to read the material, but feel free to move through it at a pretty brisk pace when it comes to chapters 12 to 18. To be honest, you probably need to do that anyway, given the size of the Bates textbook, but you can move a little more quickly through 12, 18 inclusive in that regard. If you're going to concentrate on anything, concentrate on the chapter, the study guides and my videos and the videos that we do in class. For examination purposes, that is. Returning to the Moodle site, in week 9 we're dealing with civil law. This is a particular favourite of mine because this is really the sharp edge and the practical application of environmental litigation. I would like you to look at the lecture that was recorded before a previous session with environmental law litigant Sean Ryan from the Environmental Defender's Office. That's an excellent video. Sean is very practical in nature. And in addition to that, the further resource is important. Practice directions of the court, the Planning and Environment Court, must always be considered in the context of answering a question that relates to court action in that jurisdiction. So the Planning Act is important, the Planning and Environment Court Act is important, other legislation, the Environmental Protection Act, for example, is important, but don't forget regulations and don't forget practice directions. In week 10, there is no further material which deals with supplementary material. In week 11, under ADR, we have some material. We're getting very close to the examination. I won't discount any material from week 11 and ADR, but you'll probably find that there's a lot of other material to cover, including what I've suggested I'll do tonight. Sorry, losing my voice. And that is to provide you with some commentary in relation to Booth and Bosworth, which we'll upload to week 11 and deal with in week 11, but I'd like you to have a look at that in advance. All right, so what I've attempted to do there is a flying run through of some of the materials on Moodle and give you an opportunity to provide different emphasis to different parts of that material. So yeah, so I've got a question here that was about the screensaver and civil law. Okay, so is there a text that will help in terms of understanding civil law? I'll give that some thought and provide you with some brief commentary on that. So I will do that, but I won't, I'll think about that aspect of it. So good question, thank you. Okay, so by now I trust that you've read chapters 1, 2 and 3 of your textbook. And you would have seen that in chapter 2, we're dealing with a number of important issues, including Indigenous Australians. This is always an area of keen interest to me, and I hope that you've read carefully information about Aboriginal customary law, which is long-standing and effectively operating for tens of thousands of years prior to British settlement. Customary law is often kept secret, and for that reason it's difficult to implement in practice. I trust that you've read something about the Mabo decision and you get a feel for how that led to the introduction of the Native Title Act in 1993, passed the year after Mabo versus Queensland, or against Queensland number 2, was decided in the High Court. The citation there, 1992 175 CLR number 1. Also, have a look at the decision about WIC, and you'll see that the decision of WIC peoples against the state of Queensland sparked controversy because the court decided that the grant of a pastoral lease did not necessarily grant, or extinguish rather, native title. So the federal government's response was to amend the Native Title Act in that regard. What we can say about the Mabo decision is that the doctrine of terra nullius was effectively overruled by the High Court at that stage. And it's a leading example of what we call judicial activism in practice. So you would have read about the background to it. Terra nullius is essentially British declaring Australia to be empty land. And because there was no treaty with with Indigenous Australians, because it was empty land, they said that there was no sovereignty to relinquish to the British. In other words, Australia was deemed to be settled by Britain rather than conquered as such. So the background to Mabo was this. The Meriam people had occupied the Murray Islands in the Torres Strait between Australia and New Guinea for well before British settlement. Now in 1985, the Queensland government sought to resolve uncertainty in that regard about the ownership of the islands by enacting a piece of legislation. The Act sought to abolish any claims by the islanders to ownership, and Eddie Mabo and others commenced legal proceedings to challenge the validity of the Act, arguing that it was contrary to the Racial Discrimination Act of 1975 and therefore invalid under Section 109 of the Constitution. The islanders were successful, and in order to prevent further attempts by Queensland government, a second claim was brought by Mabo before the High Court in order to have the rights of the Meriam people formally declared. So that's Mabo number 2, the application of the High Court for the declaration. And the High Court did declare that the previous view that Australia was terra nullius at the time of British settlement was simply wrong, and as a result of the continuous and ongoing connection and occupation by the Meriam people, they had traditional title to the Murray Islands, and that survived British settlement. So from there we had the Native Title Act, which formally acknowledged the existence of native title in Australia through legislation. And then we had the Wick People's decision in '96, which dealt, as I mentioned, with the issue of the pastoral leases. So there's some really good commentary in your textbook about that. And the ultimate conclusion quite clearly is that now the legal fiction of terra nullius is no longer part of Australian law. All right, so there's a question from Justice about practice directions, practice direction 1 of 2015 and 1 of 2016. Well, I'll have a look at that, Justice, and we might even, if we've got time, we might even have a look at that tonight. But I take it that you know where to find these practice directions. Actually, it might be a good exercise to look at that through UCREW. And if you wouldn't mind just asking that question again through UCREW, I'll have a look at that. And in the meantime, I'd like to ensure that you're able to find these practice directions. I know, Justice, you're able to find them. So thank you for that. Okay, so just coming back to native title, what's the relevance to environmental law? Well, it's quite significant in that if there is a finding of continuous existence of native title, then that will be applied to the management of the land and natural resources. And one thing that is clear, though, is that it is very difficult to establish native title, and those issues are determined through the National Native Title Tribunal established under the Native Title Act. All right, are there any other questions? We've had a few questions on the chat facility. Thank you. Okay, the other thing that I want you to try and just work your head around is delegated legislation and the importance of delegated legislation, where quite simply Parliament provides an opportunity for states and others, councils, to create their own piece of legislation. They don't have, councils don't have constitutional authority to create legislation, but they receive their power to make bylaws and building codes, to make declarations about roads and libraries, etc., through delegated legislation. And it's still part of the law. It still has a binding effect. And if you have any questions about delegated legislation, how that works in practice, please let us know through UCRU and we can continue that discussion. All right, so let's talk about common law. This is really the topic for this week. I'll move through it pretty quickly because the online lectures that I've already provided are quite comprehensive. But you would have seen that the purpose of common law essentially is to protect private property. That's what it was all about. And that protection was manifest in a number of different ways. For example, through common law tortious actions of trespass, negligence, nuisance, etc. So the difficulty for Parliament was to try and frame laws and policies in such a way that it would overcome, where possible, those common law rights, because the common law was not likely to move to do anything other than protect landowners, given that the concept of property was so deeply entrenched in common law. In fact, those common law rights, which have always been protected through the courts, could only be taken away through statute. And if you're looking for a good example of how the separation of powers works in practice in environmental law, have a look at the decision of Von Son against Forestry Commission in New South Wales. It's 1995 86 LG ERA at 108. Essentially what happened is that the executive sought to issue a licence, and that had the effect of taking away common law rights. And in that case of Von Son, the court said, no, the only way that you can actually take away common law rights is by statute, not through an executive act. And the issue of licenses is an executive act rather than a parliamentary act. But there are some things in the executive that do work to effectively modify common law rights, even though they can't overtake them. So, for example, the concept of biobanking, which was introduced in New South Wales in 1995, has the effect of offsetting impacts of development through biobanking agreements. So when you're reading about the executive, think about the common law, think about how the common law can be either overridden, which is legislation, or modified by the executive. And bear in mind that the whole basis of our environmental legislation is essentially to override common law rights. If it wasn't to override common law rights, we really wouldn't need environmental legislation. So the legislation is introduced to deal with environmental concerns, and it will have that effect of modifying or even removing environmental common law entitlements. And the whole idea is to look at the public interest rather than individual rights in that regard. Also, have a look at Cudgeon Rutile, number 2 against chalk. There's a really good comprehensive commentary in the study guide about that. And the only other thing I want to bring to your attention about the study guide for week 3 is really the defence of statutory authorities. And be aware that in the exercise of public function, regulatory authorities, which is the executive, may actually commit a nuisance or commit negligence, which is a breach of common law. So Parliament has introduced these statutory authorities as an exemption from the consequences of executive actions. Essentially, if the executive acted in good faith and pursuant to a statutory function, they could rely upon this defence. And there is a comment here about, yes, the main issue seems to be about public interest. And I think that's right. So when you're reading the material, think about the effect of climate change. That's always going to be a hot topic for environmental lawmakers and how they overcome environmental common law rights. And finally, on the issue of defences, have a look at the Environmental Protection Act, section 319, and that deals with the concept of general environmental duty. This is a really good one to have up your sleeve because it says basically that a person is not to carry out an activity that causes or is likely to cause environmental harm, unless they take reasonable and practical measures to prevent or minimise the harm. So that's for the general environmental duty. Keep that section up your sleeve. You may be able to use that to advance an argument for or against a party that is suggested to have acted in a manner that is contrary to environmental law. It works both ways. Okay, I know I've been doing a lot of talking. I said that we'd try and move through as efficiently as possible. So I don't propose to go to much more detail tonight. I appreciate there's a lot of reading in the material and I want you to keep on top of that. So are there any questions, comments that you want to raise before we wrap up? And I know it's an early session for tonight. All good? All right. So what I'll do is, Justice, if you could ask that question about the practice directions and we'll follow that through. I will provide some material on Booth and Bosworth. I'd like you to balance the amount of reading from your textbook with the practical material that I provide each week. And I'd like you now to read about the first and second assessments so that you can work backwards and you can try to incorporate material that you read as you go into your assessment notes so that when you come to write the assessment, it's not daunting. Essentially, it's a G-up to say, don't leave it till the last week. That could be dangerous because there's so much material to cover. If you know what you generally want to achieve, have the heading set out, then you can perhaps work towards filling in the gaps as you go, as you read the material. I hope that's some help. All right, well, thank you.
Hey, John.
Yes, Justice?
I noticed that the previous Zoom session recordings are getting removed and being replaced by the current week's Zoom sessions. Are we going to get all of the recordings at some point, or do we just have to keep up with what is current for every week?
Yes, you need to keep up with what is current. So what I'll do is try to keep you informed as to the reading that you need to do, and the weekly sessions, they do bounce around a bit. Ultimately, you need to read through all the materials. So don't be too concerned if they don't align directly. That is the sessions that we're doing, recorded sessions with what is on Moodle, but we'll try and keep it roughly similar. Does that answer your question, Justice?
Yes, thanks, John.
Okay, great. Thank you. All right. Well, thank you very much for joining us. I really appreciate when we have people live for these sessions, and what is it? The new law links. Now, I'm not sure what that means.
Sorry, John.
Yes.
John, when you were talking about the current legislative changes with common law and the other branches of our referencing points, could you please update us? Because I'm in New South Wales at the moment. I'm trying to look at Queensland legislation as well and trying to, I guess, bridge both Queensland and New South Wales legislation to my current work situation. Which environmental law is a very, very big part of what I'm doing at the moment. I'm getting so confused with the different legislative changes, and New South Wales is so different to Queensland. It's sort of like really sort of doing my head in at the moment.
I know, I appreciate that's hard because there's so much to cover in environmental law. I'm trying to condense it as much as I can. But you are right. So in essence, in Queensland, the main change has been the introduction of the Planning Act, which replaces the Sustainable Planning Act. That's relevant mainly around the middle part of the course when we talk about issues to do with planning and the planning process. It's also relevant for the Planning and Environment Court, which is the key court dealing with merits reviews in Queensland. So in terms of changes to legislation, that's the main one in Queensland. And I'm sorry that's not tailored to the New South Wales version, but there are some excellent textbooks on New South Wales, but I'm really concerned about you reading more than you've already got. So I'll provide you with some detail about Good New South Wales material to supplement that. The other thing is, in terms of Queensland practice directions, I appreciate that it's even more work for you to have to try and find the counterparts in New South Wales. I'll keep that in mind, and if I can assist you in that regard, I'll do that. The lectures that I provide on Moodle in advance are really intended to be my commentary about Bates. They're based on the 8th edition, but it's very close in terms of the content between 8 and 9. So the reason I put up the chapter comparisons is that if I'm talking about, chapter 10 in the 8th edition, that might be, for example, chapter 9 in the 9th edition. So it's just a way of reconciling that. So what we'll try to do is provide you with some hints as to where you should be concentrating your reading, and I'll keep that in mind that I'll try to assist you with that conversion to New South Wales as well.
Oh, John, I'd really appreciate that, because
Okay.
I'm already starting to go through the Protection of Environmental Operations Act 1997, number 156, which
Okay.
I've got to deal with at the moment. And I'm also having to deal with legislation that's retrospective, and then to try and bring it into line with mining and quarrying legislation, which is a whole nother world of pain for me.
And that's tough. And it really is tough when we've got the different state pieces of legislation. The other thing you can do is to raise these issues on UCRU, and it gives me a prompt. It gives me some specific guidance. The reason I encourage everyone to ask questions on UCRU is that then it's not seen that I'm, giving special advice or individual advice to students. I'd rather we have like an open discussion, and that way we can all see the responses. Okay.
Absolutely agree with you, John.
Yeah, thank you.
I've actually got access to that now this week. I've had a lot of email problems since Moodle has changed. So there's been a lot of hiccups trying to get onto this actual site. So I will post them, and I will actually respond to the questions. So thank you very much.
No, that's great. And I should mention that don't be concerned thinking that you've done something wrong if you can't get access to UCRU. I don't know if I explained this or not, but what happens is I've been using UCRU for some time. I was the first one to trial it through the law school. I like it. I use it. Others don't, but I do. And I set up my courses about a month out, and I set up the links to UCRU. They all worked. Then a week before we started, I got word saying that everything's going to change about the links to UCRU, all very new and exciting. I made the changes I had to make, but what I didn't realise is in the back room, the UCRU had to effectively register all students, and there was a delay. It should have happened at the start of term, so I'm sorry you were one of the late ones, but I'm so pleased that you're now able to have access to UCRU. Now, Justice asks a question about the Assessment 1, which is the Brandbit case, and reference to 2017 QPEC 3. It refers to the Sustainable Planning Act and the Planning Act interchangeably and finds it a bit confusing. Okay, again, even though it's for an assessment piece, I don't have a problem in discussing these things if we're all in on it, if you know what I mean. So Justice, please feel free to raise that as a prompt for me on UCRU. You'll find it's more sort of a collaborative approach that I like to adopt. And you're right, because the Planning Act is so new, it's only just hitting, there is going to be for a long while interchange between the Sustainable Planning Act and the Planning Act. And sometimes a matter that's decided now will still be decided by reference to the Sustainable Planning Act, because that was the act in force at the time that the event occurred, even though the decision is only coming out now. So we won't have a lot of decisions just yet about the Planning Act per se. Most of the reading that you'll have relates to the Sustainable Planning Act. Then there'll be that mental adjustment as to what that might be under the current law. Sorry, It's the nature of a transition from one act to the other.
That's fine, thanks.
Thanks, Justice. All right. Okay, well, can I say this? You're all doing very well. I know there's a mountain of material. Let it go over your head just a bit. Move through it fairly promptly. I'll give you some hints as to the most important parts. Obviously, if I give you a hint on an exam, write that down and concentrate that. If I tell you that you don't need to worry too much about this, that is basically saying it's not going to be on the exam. But I'd still like you to read it. Okay. All right. Thank you very much for your attendance. We'll see you next week. And please ask some questions on UCRU and make sure you do those weekly problems. All the best. See you then.